So, Andre, is the HQL gone? Have we won?
Not yet.
Welcome to the Urban Defense Podcast. I'm Duane Urban, along with Andrew Saller, the managing partner of Saller, Lord, Ernstberger, and Inslee. And in today's episode, we'll be talking about the 2024 Maryland legislative session, as well as an update on the HQL litigation. This is the first video in our series on the 2024 Maryland legislative session. Our returning guest today is Andre McDonald from the McDonald Law Firm. Andre is extremely dialed in on firearms legislation and litigation, both locally and nationally, and he'll help us to break down the proposed laws and litigation, as well as understand any challenges that they may encounter. So, Andre, welcome back.
Oh, thank you for having me back, Duane, and a Happy New Year to you, both to you and Andrew.
Yeah, thank you for coming back, and Happy New Year to you. And Andre, thank you so much for dressing up so nice for tonight. I really appreciate it.
Andre, you look beautiful. Look at those socks.
I appreciate it,
You got
man.
matching socks? Who makes that tie there?
Yeah, I have no clue.
Coming right from the office, I assume.
No, I actually had court today in Montgomery County.
Very good, very good. Okay, well, thank you for being here. So, can you tell the audience a little bit about who you are and your background and how you stay so dialed in on these laws?
Well, generally on a daily basis, I get an email in my inbox as a member of the DC Bar, and it outlines cases that are happening from coast to coast. But for me, what piques my interest are the cases primarily pertaining to Second Amendment issues, whether it's challenging state law or federal statutes, and more so, how are those litigations similar to what's happening here in the state of Maryland, primarily around the HQL issue and as well as SB 1 from last session.
Okay, so specific to the HQL, what's going on with that?
Well, recently the Fourth Circuit Court of Appeal has granted an en banc review, which is a review of the entire Fourth Circuit. We'll take a look at the case now. So some procedural history on the case. This case has been around almost, 10 plus years now. The original case was brought, I want to say, 2016.
2016, okay.
And it was dismissed on some procedural grounds. Legalese is like stand-in. The original petitioners did not have stand-in. They appealed. The Fourth Circuit sent the case, reversed the district court and sent the case back to be actually reviewed on the merits. The district court ruled against the petitioners in that case, and they finally filed an appeal on the merits. And the Fourth Circuit recently ruled on a 2-1 decision that the requirements of the Maryland HQL violates the Second Amendment under the Bruin standard. Previously, let me just backtrack a bit. When the Maryland shall issue brought the case originally, this was prior to the Bruin decision, and when the district court ruled on the merits, they ruled that it did not violate the second because they were analyzing it under the Heller standards and such. They were basically using a means test, a means ends test. And post Bruin, that test went away. So under the Bruin standard, you have to look now, and is this a type of regulation throughout the history and tradition of the nation? Was this a type of regulation that was enacted and was not offensive to the Second Amendment, to lack of a better word?
Can you point to a historical analogy of requiring an HQL?
No.
And then just so everyone understands, for an en banc appeal, how many judges then are going to hear it for the Fourth Circuit?
It's all the judges that sit in the circuit. It's the entire circuit.
So we're going to be going from 3 judges to 15.
Yes.
So why is that? Why did only 3 hear it initially, and now we're at 15 for the average person?
Well, when Congress set up this system procedurally, you have the district court where you have a single judge, and then you have the first leg of the Circuit Courts of Appeals, where all cases are heard by a 3-judge panel. Randomly, these 3 judges are picked, and they sit and they hear cases. The en banc review is not a mandatory review, whereas your review from your district court ruling, the losing party always have a right to review, file an appeal with the circuit court, which is a mandatory review. The en banc is discretionary. Likewise, a cert petition to the Supreme Court for review is also discretionary. The court does not, most cases, the Supreme Court does not have to take because it's not mandatory.
So the judges on that Fourth Circuit, then they have to agree to hear that case.
In the en banc review, yes, but the initial mandatory appeal, your mandatory appeal rights that you have as a litigant, it's a 3-judge panel.
So the appeal of right, the 3 judges are going to be randomly assigned and hear it. But all 15 have agreed, not all 15, but a majority of the 15 have agreed to hear this en banc, correct?
That is correct.
So all 15 will hear it. So just because we were victorious 2-1 on the direct appeal does not mean we will win this en banc, unfortunately, correct?
That is correct. But I brought for some reading for Duane,
Oh,
and
thank you.
I've read this opinion, and it's pretty solid. The legal reasoning is pretty solid, and I think we have a chance in affirming this decision.
So let's just talk about the timeline real quick. I know we have people whose HQLs are coming up for renewal, and they're going to say, oh, I don't need to bother renewing them now. I don't feel that's a wise course of action currently, but I want to hear from you, Andre. How long is this going to take?
You are correct. Let me just put it out there. Right now, status quo. If you're trying to purchase a firearm in Maryland today, you still will be required to have the HQL. This could be, I would say, probably early summer, we should have a decision. It's going to take a few months. And the decision does not mean that's the end of it, because the losing party still has the ability to petition the U.S. Supreme Court for review.
We're going to take it all the way to the Supreme Court.
Yes. And that's a discretionary review on the court's behalf. And if the Supreme Court grants a review, that case will not come up for hearing until the next session, which starts October 1 of this year.
And in all likelihood, it wouldn't be till October 1 of 2025, correct?
Probably. And a decision will not come probably till the following summer. So
2026.
Exactly.
So anyone who's watching, listening, and anticipating saving money on their HQL renewal.
No, unfortunately, no, you still have to go out and get that HQL. If you're a first time purchasing a firearm, you still need to go get it. And if yours is about to expire, you need to renew it.
Yeah, I couldn't tell you how many calls I've received from people saying, hey, I heard that you don't have to have an HQL anymore. And I'm like, well, that's not true. And then you explain it to them, and they don't know what quite to make of it.
Mutual friends of ours who all want to sign up for a class action lawsuit to sue the state. Not ripe yet. Not ripe.
Okay, so any more on the HQL front, or should we move on?
Well, stay tuned. Stay tuned. I'm hopeful in the reading that opinion. I think you should, if everyone has a chance to look at the summary of it, is Maryland shall issue versus Westmore. It was substituted somewhere online. You may see it as Maryland shall issue versus Hogan.
Who's that?
That's the former governor. And once,
don't know that guy.
Once his term was over, he left.
He was a Democrat, wasn't he?
What was he really?
Yeah,
I have no clue.
I don't think he does either. So
no labels, gentlemen. no labels. No labels.
So they had to they substituted and placed Westmore as the defendant for the state. So if you look it up, it's Maryland shall issue versus Westmore, and it's the logic reasoned by the majority in the case. It's pretty solid. And looking at the history and tradition, Maryland argued 2 prominent issues that why the HQL requirement should stand. One, that the requirement is there to keep firearms out of the hands of dangerous individuals. The court easily dispatched of that. It was like, we have other laws that do that. If we have federal law that says if you're prohibited already, you are prohibited.
I just don't show up and show my HQL. Don't have to bother filing a 77R. I can just show the HQL and walk out with a firearm now in Maryland. No,
Gun show loophole. I
Yeah,
believe.
yeah.
No, we're not there yet. We're not there
okay.
yet. And then the court looked at, even if you're a law-abiding citizen and you jump through all the hoops that the state has put in front of you, all those hurdles, you still cannot obtain a firearm. You still have to wait 30 days. And in one of the footnotes, the majority went on to say 30 days is just a minimum because it's not including the time you have to take to be fingerprinted. You have to get a class. Usually these classes filled up pretty quickly. You have to get the range time to do the range component. Then you have to fill out and submit the application, and you still have to pay the fee and wait the 30 days. If you're successful at every interval, you receive the HQL, and now you walk into ABC gun store. You cannot purchase the firearm and leave. You still have to wait another waiting period.
Astounding.
So while the court, in this opinion, did not rule on those other proverbial issue, in the legal field we call it, in dicta, they touched on it. They just brushed over it and say, we'll take that on another time.
Okay.
So stay tuned.
So, Duane, we're still going to need to take some classes from you to get our HQLs.
Well, happy to provide those. So for those who watched previously, you know that we covered a bunch of legislation in the 2023 Maryland legislative session. It was something like 49 bills, give or take, many of which we discussed. Compared to this year, where we're really only talking, I think, about 6 or 7 bills, at least these are the main ones that would affect most of you. There were some things in there about capturing data, reporting data, and law enforcement stuff that doesn't really apply to many of you. So we stuck to the ones that we thought were going to be most relevant. So, guys, why the stark difference in the number of bills this year versus last year? Is there any rhyme or reason to this, or what's going on?
The state is broke. Maryland is out of money. The cities are out of money. The counties are out of money. Every municipality is out of money. And they are down in Annapolis like cats in a bag fighting over who gets caught and whose taxes are going to get raised.
Got it. Andre?
I take a different approach from Andrew. Maybe he's more dialed into Annapolis than I am, but I would like to say, specifically with regards to legislation on the Second Amendment front, I think the district court ruling in SB 1 was a really, that up and in fastball and you brush it back off the plate. It probably just pushed them back a bit.
It may have. I mean, it was a big deal.
Yeah, they just went all in after Bruin came down and just basically said, we're not going to stand for this. And federal courts just pushed back.
I hope you're correct, Andre. I know these people. They want your guns yesterday.
Thank God for the Second Amendment.
From my cold, dead hands.
Yes, yes. So so with these bills that we're seeing, these 6 or 7, whatever we're going to be talking about, is this all that we can expect for the viewers out there? Is there a cutoff, or could we expect somebody to throw something in after today?
They have plenty of time still to introduce more legislation. The session just began, goes for 90 days. They still have ample time to introduce new bills. Crossover day is still going to be weeks away. So anything that could still be introduced in the coming weeks could certainly move to the other chamber and move forward and become a law.
So new bills could, in fact, appear. This wasn't the last day for filing everything. They could still put something in?
Absolutely.
Okay.
Don't count our chickens before they hatch.
So in that same vein, maybe for the benefit of the viewers, Andrew, could you maybe go over how a bill gets introduced, how it works its way through the colon of Annapolis and then comes out of where to become a Maryland law?
So either the Senate or the House, one of our fine legislators would have to introduce a bill. It would be referred to a committee. It would have to be voted out of that committee successfully, have to go to the House floor, all throughout this process subject to amendments. Survive amendments on the House floor or the Senate floor, pass a third reading, which is the final time, no more amendments after that, and then it would cross over to the other chamber, and then it would have to go through a committee there, once again, be read up to 3 times, subject to amendments, And then if the two bills are identical, sent to the governor. If they are not identical, it needs to be sent back to the originating chamber to resolve any differences between the two. Eventually, it's sent to the governor, and he has the opportunity to either sign it into law, veto it, or allow it to become law without his signature.
Okay, and how does that happen? He just abstains from signing, but he just does nothing and it becomes law?
For Governor Hogan was famous for doing this for policy proposals that he did not agree with, but the Democrats have a supermajority here in the Maryland legislature. They were going to override his veto. He would just allow certain things to become law rather than veto them and have his veto be overridden.
Okay.
Yeah, pocket veto.
Except it's the opposite.
Yeah.
A pocket pass.
A pocket pass.
No labels.
No labels.
All right. So with that said, let's go ahead and get into it. So in no particular order, let's go ahead and start with House Bill 21, straw purchase participant. This is sponsored by Delegate Dalia Attar. No?
Well, yeah.
Was that right?
Yeah.
Okay. They gave me a hard time about saying the name, so I want to make sure I got it right. So Dalia Attar, Democrat, Baltimore City. This was introduced last session, 2023 regular session, as House Bill 159. So, Andrew, do you want to tell us about that?
This bill, it's designed for a very specific purpose. If you commit a straw purchase, a police officer cannot arrest you unless you do the straw purchase in front of them because it's a misdemeanor not committed in their presence. They would have to, currently under the law, go and get a warrant from a district court commissioner before they could arrest you. This adds a straw purchase to a very small list of crimes that they are misdemeanors, and an officer can arrest you for, even if it did not occur in their presence, if they have probable cause to believe it occurred. I am not sure how many people would be charged under this section, and how much, is there a call for this? How many officers are encountering straw purchases and they say, darn, I would arrest the guy, but instead I'm going to have to go to the district court commissioner and chase him down?
Well, generally, if there's a straw purchase taking place, and let's say the girlfriend is buying it for the boyfriend because the boyfriend is a prohibited person, the moment she gives that gun to that person and he possesses it, he's in violation. So I don't know what usefulness this has.
Well, this would allow the officer who somehow has ascertained that this occurred could then go arrest the girlfriend without getting a warrant first.
Okay. Probably not used very much, but, it's there.
Yeah, I question how often this would be invoked. Okay. I'm not saying it's good. I'm not saying it's bad. I would need to see more data to figure out why we need to do this. Your thoughts, Andre?
I'm just still trying to figure out how they actually, the intent of the individual to commit what is this, general intent? You need specific intent?
You would need specific intent.
I'm more thinking this is a solution looking for a problem.
Well, and once again, this doesn't make the straw purchase illegal. This just allows a police officer to arrest you without obtaining a warrant first. And it does increase the penalties. It does do that to 10 years and a $25,000 fine. But currently, the list of crimes that an officer can arrest you for misdemeanors that did not occur in his or her presence include manslaughter by a motor vehicle, malicious burning, malicious mischief, theft, the crime of giving or causing to give a false alarm of fire, indecent exposure, a crime relating to controlled dangerous substances, the wearing, carrying, or transporting of a handgun, carrying or wearing a concealed weapon, prostitution, violation of a condition of pretrial or post-trial release, and potentially adding knowingly being a participant in a straw purchase of a regulated firearm.
Okay, moving on. House Bill 41, Violent Firearms Offender Act of 2024. This is sponsored by Delegate Nino Mangione, Republican, Baltimore County. This was also introduced in a prior session, 2023 regular session as House Bill 952. Andrew.
This bill increases a lot of criminal penalties and removes the discretion of a district court commissioner to release certain people that are charged with certain offenses. I am not saying this is a good or bad piece of legislation, but it has a snowball's chance in hell of getting actually passed, chiefly because of who the sponsor is. Key things amount it, even for a first offense, a district court commissioner could not release someone who's charged under this provision. It would increase the mandatory minimums under certain sections here. And it's a very hard on crime type of bill that is rather unpopular in Annapolis in the current setting.
I concur, Counselor.
So not much chance of that one. So now what's interesting, and Andre, you and I spoke about this over the phone, as we move into Senate Bill 28, also called the Violent Firearms Offenders Act of 2024, this one here, sponsored by Senator William Folden, Republican Frederick County, and 12 other Republicans, also was introduced last session as Senate Bill 744. Why these two similar bills, Andrew?
Duane, one's coming out of the House, and they're not identical. They are not cross-filed, and one's coming out of the Senate. Very similar subject matters, very similar approaches. Both target people who steal firearms, both target people increasing mandatory minimums for misuse of a firearm and a crime. But once again, the current political climate in Annapolis is not supporting increasing mandatory minimums or increasing penalties on a wide range of offenses.
So could these both pass and then become law similarly named, or would they have to be joined in some way?
Eventually, the differences between the two would have to be reconciled by either the House or the Senate and made identical.
Okay. Andre, thoughts on that one?
Well, I'm with Andrew. With the current political climate, it's less likely that increased punishment penalties are going to be enacted.
I would support putting criminals who steal firearms in prison.
Absolutely. And with that said, that puts us to Senate Bill 39, the Gun Theft Felony Act of 2024, sponsored by another Republican, Justin Reedy, Republican Frederick and Carroll County, and 12 other Republicans. And again, just like the previous two, this one had been previously introduced in the last session, but went nowhere.
It's been introduced every year since 2018.
Wow.
And it has never gone anywhere.
So what does it do? What does it say? What is it proposing?
It makes the theft of firearms a felony and establishes minimum sentences that if you are convicted of stealing a firearm, you're in trouble.
So interestingly enough, you mean that the stealing of a firearm isn't a felony?
Come on, man.
No,
Oh.
depending on its value.
Okay.
It's like any other piece of property.
Okay. Andre, thoughts on that? You think it'll see the light of day?
How long it's been introduced and how many years now?
2018?
Yeah.
This will be the year. This is going to be
We're
the
going
year.
to get it this year.
Yeah.
You know the old saying, first you don't succeed?
Yeah, try again.
Well, try again.
Maybe this will be the year.
Yeah, right now, as long as you were stealing a firearm that was worth less than $1,500, it would only be a misdemeanor facing a maximum of 18 months incarceration.
Let me say this. If this couldn't make it into SB 1 last year, when everyone in Annapolis was ready to go after, get something passed.
Well, I think they were more concerned about you carrying guns as opposed to stealing them.
Well, in order to get the votes, you just have to pile stuff in there. You want my support on your bill? Here, you have to take my amendment, attach it to yours.
Yeah.
I don't think they needed any help, though, if you remember.
It's a what? It's a 5-1 majority or something. What is the majority in Annapolis? Some ridiculous number, I'm sure.
Right now in the Maryland
Producer Jimmy, you gonna grab that for us?
Yeah. What are the numbers of how many Republican state senators and how many Republicans in the Maryland House of Delegates
Versus the Democrats.
And I'm sure it's not going to be a pretty number because I distinctly remember in 2022 the Republicans lost state Senate seats and several House seats.
Right. Well, it wasn't very good to be before that.
No,
So
no,
it's
and it only got worse.
Okay, so while he's looking that up, let's move on to the next one. And again, it's going to sound very similar. Senate Bill 179, the violent firearm owners, or I'm sorry, violent firearm owners. That's what they think we are. The Violent Firearms Offender Act of 2024, sponsored by Senator Ron Watson, Democrat, PG County, and one other Democrat and one Republican, again introduced in the prior session. What is it? What does it mean, Andrew?
This one is a little bit more complicated than a lot of these bills. This establishes that a violation of probation or parole that involves the use or possession of a firearm is not a technical violation. Now, a normal person is going to go, what the heck does any of that mean? In Maryland, under the Criminal Justice Reinvestment Act, technical violations are capped at a maximum of 15 days of incarceration. So I really would struggle to envision a scenario where you would use a firearm and violate your probation, but it would be a technical violation. Technical violations are you had a missed reporting with your probation or parole agent, or you had a dirty urinalysis with your probation or parole agent. Something substantive, such as shooting someone or being in possession of a firearm, those would not be covered as technical violations to begin with. So I'm unsure where there's the need for this.
So again,
a solution looking for a problem.
Exactly. So then what's the purpose? Just to try and throw something in there and say, hey, we're doing something? I mean,
it's got some other elements too. It requires the Commissioner of Correction to provide inmates with reentry kits to assist them in obtaining Medicaid benefits, things of that nature. I'm not so sure. This is a catch-all bill, and you see it does have Democrat and Republican support to go after people that are using firearms improperly in the community.
But let me ask this, Andrew. But by definition, if you're on parole, you on both state and federal law, you are prohibited. You are a prohibited person.
It would be very difficult to find a situation where a parolee would be eligible to purchase or possess a firearm. It would be very difficult. I cannot imagine one off the top of my head. And then a standard condition of probation is that one will not possess firearms without the court's approval.
So again,
For
solution
now.
looking for a problem,
Yeah.
like you said.
No, because I know this is a discussion for a different video, but there are cases, litigation around the country that are trying under brewing that are trying to get to some of these issues.
Absolutely. Those, though, have generally, as I understand it, you tell me, though, more focused on the rights of people who are prohibited persons due to aged and decayed convictions for crimes such like tax fraud, who are now prohibited to have their rights restored.
Yes, those are part of it, but there is a case. The circuit is slipping me right now, where it's an actual domestic violence issue, where the petitioner in the case is arguing that under Bruin, basically was that a Lautenberg Amendment should not apply.
He got the protective order against him
Yeah.
and then became a prohibited person during the period of it. Yes.
So these cases, they're making their way. They got out of the district court and they got it. Some of them are into the circuit courts, and a lot of the district court rulings are basically, some of them are in fact, some are stayed while the litigation proceed. The next year is going to be I want to say a watershed moment for a lot of these thorny issues with regards to whether or not certain prohibited individuals or individuals who become prohibited, can they be in possession of a firearm?
I'm going to hold you to that, Andre.
I'm an eternal optimist.
All right, so moving along to Senate Bill 324, handgun permits, accidental discharge, and training requirements. This being called the Firearms Safety Act of 2024, sponsored by Senator Corey McCray, Democrat, Baltimore City.
This bill, if you have, some would call it an accidental discharge, others call it a negligent discharge. If this occurs, you would have to take additional training or you would lose your permit under this proposed piece of legislation. The state police would have to maintain a program to both inform you that this occurred and then give you 90 days to get into compliance. Yes, to get into compliance within 6 months of the incident.
Yep.
Now, Andrew, throughout the history and tradition in the regulation of firearms, have we ever seen anything like this?
I am unaware of it. I will admit I am unaware of the policies regarding negligent discharges at the ratification of the Second Amendment or the ratification of the 14th Amendment.
So unlikely to have good standing.
Well, as I usually say to my clients, is that the legislature is going to do what the legislature does. They're going to enact a law, and then it is up to litigants to challenge it. And we have to basically bring a case saying that this particular section of the statute violates my Second Amendment right, and let the federal courts decide.
Well, in order to do that, you're going to need, though, the perfect plaintiff who has a negligent discharge, doesn't do anything criminal during the course of the negligent discharge, doesn't hit anybody or anything of any value because they're going to get sued into oblivion, and receives this letter from the state police and then challenges it. Is that a fair concern, Andre?
Generally speaking, that's how standing the case would. That's how you have a very ripe case. But it's yes, that is you have a very ripe case, a clear controversy. For those our viewers out there, federal courts are not in the business of giving advisory opinions. You need to have a clear case and controversy in order for the courts to move forward.
You have to have a real plaintiff that
Yes.
has something to gain or lose by this, not just, I don't like this law and I want to challenge it, correct?
Yes.
So this situation we're describing, we would really struggle to find a good plaintiff. Is that a fair statement?
I'm not going to go that far.
Okay.
Because knowing Duane, and since Duane and I have been working together, some of the things that he has shown me and I've seen, you will believe that finding a good plaintiff, it will be difficult, but I don't think so.
Okay. Well, the real solution here, ladies and gentlemen, avoid negligent discharges.
Yeah. Trigger finger discipline. Obviously you want to have a safe direction, but certainly trigger finger discipline and making sure that we don't have those negligent discharges.
Get trained up at Urban Defense.
Yeah. Look, get good quality training. We do provide that. But that is the thing that I see in classes more often than not, other than just general fundamental issues, is going to be where people, they want to put that finger on the trigger, and you try to teach them that high touch point. And they understand that they shouldn't be doing that. They shouldn't be putting their finger on the trigger. But for whatever reason, you turn your back and boom, they're right back on that trigger.
Duane, do you not like the movies?
I get it that many of the people that come to us have their formal training from Hollywood.
I've watched Rambo.
I mean, not Alec Baldwin, but
Yeah. Oh, yeah.
Yeah. I mean, that was a good firearms safety lesson there.
So are you saying that if I was to be practicing drawing a firearm and pointing it and pulling the trigger, I should maybe check to make sure it's unloaded first?
I think that would be well advised. And I also think that aiming it at another person that you don't intend to actually shoot probably would not be a good idea as well. I mean, it seems like common sense, but again, common sense isn't so common. And Andre's right. We've shared a lot of stories about different things that I've seen or that he's seen over the years. And I get to see a lot of it. I get to deal with a lot of different folks in these classes and people of all different backgrounds. And, you don't know what you don't know until you know it. And we learn about things from different sources in our life. Maybe it's our grandfather, our uncle, Hollywood, like you said, the movies, or the internet these days. internet videos, YouTube and things. And it's difficult to break people of those things. So you've established muscle memory. You're used to putting your finger on the trigger because that's just what you do. And now I'm telling you, some guy in a class somewhere is telling you, don't do that anymore. You've been doing it for 30 years. And it's a lot more older folks than it is younger folks. People that have traditional firearms experience, they want to put that finger on the trigger. So it's something that you've got to break them of. It's a training scar that they've created. But yeah, absolutely.
Are you insinuating that the couple that was outside of their home with the AR-15 and the wife with the pistol and she's got her finger on the trigger, that may not have been the best trigger discipline with the mob right there?
I would say there was a lot wrong going on there. I'm not saying that people shouldn't have the right to protect themselves, but yeah, she came out of the house looking like she had never held a handgun before in her life, holding it up over her head in some weird way, at least in the photos and videos that I saw. That's obviously not going to work out well. And God forbid they would have needed to use those firearms to protect themselves or someone else from serious bodily injury or death. I think they would have been in big trouble. I think they would have been way in over their heads.
With the finger right on the trigger when she's got it above her head.
Yeah.
Absolutely.
Yeah. And again, it's easy enough, well, maybe not in Maryland, to go and get the licensing and to go and get the gun and then to take the gun. And we talked about it in the last video, take the gun and you buy some ammo and you put it in the closet or wherever you put it or in the safe, and then you do nothing for years. And what have you done? You've trained yourself for failure. Because what are you doing to continue your education? What are you doing to reinvigorate these perishable skills? You're not doing anything. And if the time comes, and it's life, bad things happen, if the time comes that you need to use that firearm, that's not a good time for on-the-job training. So you better hope that things go your way, or it'll end very badly.
I can certainly agree with everything you just said, and we can all agree negligent discharges are no fun.
They are not, and this law will take care of that, apparently. They will stop immediately overnight.
Rest in peace, negligent discharges.
Just like the drug laws stopped all the drugs. All right, and that leads us then to the final bill, unless either of you have something else you want to talk about as far as bills. Senate Bill 326, questioning of a juvenile, crime of violence, or crime involving a firearm. This is sponsored by Senator Mary Carrozza. Did I say that right, Andrew?
Yes.
Oh, very good. Somerset, Worcester, or as they may say, Worcester. Okay. And Wicomico counties as well.
Also, Wicomico.
Is that how some people say it?
First time I got called out when first time I was there. You're not from around here, are you? This is Wicomico County.
Yeah, that sounds a little interesting. But yes, Somerset, Worcester, and Wicomico counties, as well as 2 Democrats and 2 Republicans. So what is it?
In Maryland, this is a very hot topic this session, both on the Democratic and Republican side. Producer, did we figure out how many Republicans are in the
Republicans and Democrats? How many Republicans versus Democrats in the
Maryland General Assembly?
You were supposed to be looking that up. What'd you do? Start around over there? What, you jack your over there?
Prevert.
Come on, man.
Just
General Assembly.
Maryland General Assembly.
Give me some numbers here.
Breakdown. Democrats versus Republicans.
There we go.
141 total in the House of Delegates. 102 Democrats to 39 Republicans. All right, what about the other side? All right, so 34 Democrat state senators to how many Republicans? 13.
That sounds right. Little lopsided. 34 to 13 in the state Senate.
Okay, well, there's our answer. I don't have the exact percentages, but that's good enough.
So it's very controversial. The previous session, they passed a law that dealt with juvenile interrogations. Now, if the police arrest a juvenile for could be a lot of things, they are not allowed to interrogate that juvenile until an attorney has spoken with them. As a result of that, Republicans are kicking and screaming that we have all these juvenile lawbreakers and the police are not able to interrogate them to develop additional evidence, develop co-conspirators, and assist the prosecution of crimes. Other people, from the more liberal side are saying this is wonderful. We're protecting these children. But at the same time, they are getting some pushback from their constituents with the numbers of carjackings that are occurring in the Baltimore metropolitan area, burglaries. And there was just the scandal that a large majority of the youth that were being intaked in the city of Baltimore were being improperly released when they should have been held. As a result of all this, people are agreeing there may need to be reform, just there is a huge debate as to what, if anything, should be done about this. This bill is aimed to add exceptions to the general prohibition about interrogating children, that you could interrogate them about certain firearms crimes without having a lawyer present or their parents.
But I'm going to play devil's advocate here for a bit. If this bill goes through and becomes law and any interrogation, these juveniles still have, as all Americans do, a Fifth Amendment right to counsel. You will still have to Mirandize them, correct?
Absolutely.
And they will have the ability, whether or not, to invoke that right.
Absolutely.
And the question becomes, does a 14-year-old or a 15-year-old have the wherewithal to say, I'm going to invoke this right? What does it mean to invoke my right to counsel? That's your area of expertise these days. But I think a blanket immunity that, okay, you cannot interrogate at all, I think it's going a bit too far, because the government still has they still need the ability to solve crimes. And at times you may need the cooperation of a witness.
Well, what if I say I want a lawyer dog?
Lawyer.
Do you have to bring them a lawyer and a dog?
This was a famous case that went all the way up to the Supreme Court where they started interrogating a young man, and he said, I want a lawyer dog.
And what did they do? Did they bring him a dog?
They did not bring him a dog.
Because then they could have brought them both and they would have been in compliance.
Yes, and they ended up determining, I believe, that some people viewed that he was saying dog as a pronoun for a fellow male, like my dog. Other people felt that he was asking for a lawyer who happened to be a canine.
I do believe that's the Miranda and Baxter clause that they're referring to.
So this went up on appeal, and the latter impression was what the court went with, that he was asking, I think may not have been the case, but asking for a lawyer who happened to be a dog.
Ah, is that what they determined?
Yes. And so they felt that that was not a proper invocation of the Sixth Amendment, and they allowed his confession to come in.
Ah, okay.
All right. So final thoughts on the 2024 Maryland legislative session. I know we went over a lot of things tonight. Not nearly as many bills as last time for maybe a number of different reasons that we previously discussed. Any other thoughts or takeaways as a final thought?
I would say in comparison to last session, we can have a bit of a breather, maybe until next.
Okay.
Guard your pocketbooks. They're coming for them. Your guns might be safe this year, but your wallets, your paychecks, they are not.
So what you're saying is we won't be able to dress up in fancy suits after that happens.
Correct. We won't be able to afford to buy new firearms after this.
As we wrap up, I want to thank you for tuning in. Remember to share, like, comment, and subscribe, and stay tuned for our next episodes. So for the Urban Defense Podcast, I'm Duane Urban, along with Andrew Saller and Andre McDonald. Remember, train, fight, and win.